I call Simon Bridges.
Speaker, I have been involved in the selection of many juries. And the way it works is one where the Crown or Defence gets to challenge 6 potential jurors without cause. So this is Chester Burrow's reference to what they're wearing. And it is true that to some extent you will make an assessment of the person as they walk up to the jury box. Once they've sat down, that is it. And you also, as a prosecutor, have some reference to perhaps their previous convictions. So if it's a sexual charge and they have offending of that pedigree, you probably think about that and probably challenge them. You've got 6 multi-accused trials. You have 12, and that's whether you're defence or Crown. But I tell you what, the one rule, Mr. Speaker, that all, and Steve Chadwick's husband knows this, that all Crown and Defence know, and I'm going to bring this secret out into the open today in this House. It is a rule that all counsel in all jury trials follow, and that is this: never, ever, ever have a teacher on a jury, right? Never, ever have a teacher on a jury. And if you think of Trevor Mallard or maybe Calvin Davis, you might have some sense of why this is the case. It's because they think they know it all, right? It's because they think they've been used to lecturing and talking down to children for a very long time. Their minds are not malleable. They will not listen to decent arguments. They jump to conclusions. So I've just exposed that secret in relation to the selection of jurors, and it is something that Crown and Defence do follow. But I want to say, Mr. Speaker, this is an excellent bill that will protect more stringently jurors' addresses and particulars and will help maintain privacy, safety and security. And I thought about this bill, Mr. Speaker, when I saw this headline in the New Zealand Herald this week: 10 million drug kingpin guilty. And one can understand quite quickly, that was a jury trial, in a case like that, why people would have very strong, actually reasonable reservations about wanting their addresses known by an accused. In a case like that, so much is up for grabs, and underworlds can be involved in terms of the witnesses and certainly the accused, who will stop at literally nothing to get off the charge. And so we are doing something here to strongly protect jurors. They do get squeamish. There can be issues, understandably, with these serious cases, and it only takes 1 or 2 to feel those pressures acutely for a trial to have to be stopped, started again, for there to be delays, and so this gets around this at a huge cost to the taxpayer, actually, if you're doing that sort of thing. So if for that reason alone, this is an excellent bill. And I hear the comments made by other members about things that could be in it, but what it does is sufficient to justify it as a good bill before this House.
I call Jacinda Ardern.
Thank you, Mr. Speaker. It's my pleasure to rise and to speak on the Jury Service and Protection of Particulars of Jury List Information Bill. And I think my colleagues have made some really good general statements about the context in which I think we should be looking at this bill and the role of juries more broadly. And everyone in this House, I know, will acknowledge that the jury service, the role of jurors is critical to our criminal justice system. And unless we have a robust system which allows our peers to stand in judgment of one another, then everything falls down. But underpinning that again is a need to ensure that we do have a broad cross-section of jurors who are willing and able to serve on our juries, and that we remove as many as possible the inhibitors to them serving. Time is a massive issue. The ability to travel to court for a lot of people, very costly. These are all things that I think, in terms of ensuring that we always have a representative cross-group of people standing on our juries, that we should be mindful of. And I would be very interested as to whether or not the Select Committee is able to do a bit of analysis of those who are currently listed as having sought and received exemptions over and above those that are listed in this bill. Are, for instance, we seeing a particular profession very rarely represented at jury level because they're consistently exempted from service? Are we seeing certain age groups, cultural groups and ethnicities seeking exclusion from jury service and receiving it? And let's look at the reasons why that might be. Is it occupation? Is it family commitments? Is it cost? Those are issues that I would be really pleased if the Select Committee would spend a bit of time looking at, because I don't feel we have a true sense of whether or not currently we have truly representative juries, and that's something I would like to see addressed. The other general point I want to make before talking about some of the detail of this bill is the fact that as a previous member of the Justice and Electoral Select Committee, we've seen an extraordinary number of justice bills going before that committee. The comparison that I've seen from moving from that into the Social Services Committee, which is an excellent committee and does have a lot more time to consider systemic issues in the area that we sit across, because we're not constantly inundated with what I would perceive to be generally reactionary bills. And by that I mean, for instance, the bill that we've just finished considering, increasing the penalties, specific penalties for those who assault police officers. Of course, I want to see those who assault police officers dealt with the full force of the law. But the idea that we need to have a specific provision that sets it out within the Sentencing Act, when that's something that in sentencing we would already see taken into consideration, does feel like a piecemeal approach to our criminal justice system, particularly around sentencing. And we've seen that on another number of occasions. And I personally would rather see us as a parliament and as a select committee considering the wider systemic issues in our criminal justice system. Why is it that we have the second highest imprisonment rate in the world, second only, I believe, to either South Africa or the United States? Either way, it is an indictment. And why aren't we discussing that issue? And the fact, though, at the same time, that actually our rate of criminal offending actually isn't really increasing, and yet our imprisonment rate is dramatically. But on to the specifics of this particular bill. We've already talked about the fact that some elements of it are simply common sense. I think it makes sense that there's no regulatory impact statement for this bill, because it does only affect a very narrow pool, and those tend to be those up who are eligible for jury service and those who might seek exemption. I just want to run through the three areas specifically of the bill. One is the issue of ensuring that jurors' personal details are not revealed so as to keep them safe in the event that they serve on a jury and someone may seek them out. I would like to see the Select Committee consider that one in a little more detail, because as we've already raised, there are opportunities in court for their personal matters to be raised, and if we are going to be comprehensive about the safety of jurors, then we would be wise to look in that, perhaps in the same way that we do for witnesses or victims. And also, on that particular issue, I think now might be the time to raise the role that court and victim advocates have been playing in our court system. I've heard recently that we have varying degrees of competency for people in those roles, but that they have the potential to play a really critical role for people who are navigating their way through our criminal justice system, which can be daunting. A court, for most people, is a very alienating and intimidating thing. And having someone who's able, in layman terms, to talk you through the process you're going through, I think is an incredibly helpful thing, particularly if you're a witness or a victim. So again, something that in the guise of looking at the role that jurors play and their experience might be interesting to talk about whether or not we have people adequately performing that role for them. The second issue that I want to touch on is this issue of allowing for exemption from jury duty. So currently you're able, if you're called up to be a juror, currently you're able to seek an exemption on the grounds of occupation, business, state of health, physical disability, family commitments or other personal circumstances. I've used that provision in the law. I was called for jury service if my memory serves me correctly, when I was working for the Minister of Justice. So it wasn't at all correct or proper in my view that I serve on a jury whilst I had that role, in the way that I believe police officers and police officers' families, spouses, I think perhaps specifically, also don't serve on a jury. So my mum, for instance, hasn't served on a jury, and I believe that's contained in legislation somewhere. These are all legitimate circumstances under which you would seek an exemption, as is, I believe, the idea of seeking an exemption for a long-term disability or health reasons. What I'd like the Select Committee, though, to consider is when seeking an exemption on health grounds, this is a permanent exemption in this bill. Will a distinction be made between those for health reasons seeking an exemption because of a temporary health issue versus a longer-term health issue? Will we still be able to make that distinction in those applications if it's on health grounds? Or will it be that generally if you seek an exemption for a health reason, that will be a permanent one? I wouldn't mind hearing a little bit more from the Select Committee and considering that issue. Also, I note in the bill that that new section 15A2 imposes a duty on the registrar to excuse the person permanently if satisfied that the permanent is of or over the age of 65 years. I have to be honest, I find that slightly archaic, that we would suggest that if someone is simply of the age of 65 or more, that if they write a letter and saying that they suddenly wouldn't be allowed, they could be permanently exempt from serving on a jury. I think that's a bit ageist. I see members on the other side of the House who may be entering into those golden years themselves who agree with me that this is ageist. If you're 65 years of age, in my mind that does not speak at all of whether or not you are competent to serve on a jury. In fact, if nothing else, at that time in someone's life, often there may be more time available to contribute to one's community or community service. So why? Why have we set an age of 65? Surely, if there are grounds and a person who is a senior citizen does not believe that for physical or health reasons they have the capacity to serve on the jury, they would then be able to seek an exemption based on that criteria, rather than just their age. So I wouldn't mind the Select Committee's view on that, and perhaps I look forward to members of the Select Committee, Paul Quinn perhaps, could come back to this House and tell us what the committee decided on those issues. I know that he wasn't listening to what I thought was a very good point that I just made. I'd be happy to repeat it later if you'd like, or you can read the Hansard, because I know that you're a studious reader of Hansard. The question is, why should someone of 65 years or more not serve on a jury? So we'll come back to that issue. I look forward to hearing more on that from the member. So generally I think the provisions around people on home detention not serving jury duty, simply an issue of that not having been addressed in the original bill. Otherwise, I look forward to discussing this again with Mr Quinn at second reading. Excellent.